On behalf of the Calcutta High Court Mediation and Conciliation Committee, I, being the Member Secretary, welcome all of you to this regional conference on mediation, being organized by the Mediation and Conciliation Committee, High Court Calcutta, in association with District Legal Services Authority, North 24 Parganas. This conference intends to sensitize all stakeholders and create an ambience for strengthening the process of mediation as one of the most effective mechanisms for alternative dispute resolution for greater good of the society. And this conference even becomes more relevant in the context of new draft bill on mediation introduced in 2021 and which aims at promoting and facilitating mediation, especially institutional mediation, in a structured manner. We are extremely privileged and proud to have with us the Honorable Judges of Calcutta High Court, Honorable Justice Harish Tandon, the President of the Mediation and Conciliation Committee, Honorable Justice Subrata Talukdar, Honorable Member of the Committee, and Honorable Justice Shubhra Ghosh, Honorable Member of the Committee, to grace this occasion. May I now have the pleasure to request Honorable Justice Harish Tandon, the Honorable President of the Committee, to come to the dais and take his Lordship's chair. Learned District Judge North 24 Parganas is requested to accompany his Lordship to the dais. Lordship. May I now request with deepest humility the Honorable Justice Subrata Talukdar, Honorable Member of the Committee, to come to the dais. Learned Additional District Judge, MP MLA Court, Bidhannagar, Sri Manoj Jyoti Bhattacharya shall accompany his Lordship to the dais. May I now have the pleasure to welcome Her Ladyship, Honorable Justice Shubhra Ghosh, to the dais. Learned Additional District Judge, 8th Court, Sri Prasad Kumar Roy, is requested to accompany Her Ladyship to the dais. Now, Judgeship of North 24 Parganas intends to felicitate the Honorable Judges of Calcutta High Court with some mementos as a mark of honor, and 3 probationer judicial officers, lady judicial officers, will have the rare privilege to honor the Honorable Judges. Accordingly, Vedashruti Mollik is requested to come up on the dais and felicitate Honorable Justice Tandon. Now, Aratrika Das is requested to come to the dais and felicitate Honorable Justice Subrata Talukdar. Now, Shweta Kumari is requested to come up on the dais and felicitate Honorable Justice Shubhra Ghosh. Now, Learned District Judge North 24 Parganas is requested to deliver our welcome address. Please, Madam.
Very good morning to all of you. It is a moment of great honor for this district of North 24 Parganas to get the opportunity to welcome our esteemed guests for district level regional conference on mediation. In this auspicious occasion, we feel privileged to welcome our honorable judges, the Honorable Justice Harish Tandon, if I may be permitted to say so, Lordship, the mastermind and the man behind this whole program, as well as my Lord, the protagonist of this mediation procedure. My Lord, I heartily welcome you today. Now, Honorable Mr. Justice Subroto Talukdar, one of the member of this committee, my Lord, if I may be permitted to say so, my Lord, the erudite speaker with a subtle humor, my Lord, you are heartily welcome today. Our next guest of honor, Honorable Mrs. Justice Shubhra Ghosh, our very own Honorable Justice who once adorned the chair of Barasat District Judge. My Lord, you are cordially welcome today. Now, I would like to welcome our respected dignitaries, without whom we cannot hold this program, and including our Honorable and respected District Magistrate, Mr. Sharad Dwivedi, respected CP Barakpur, Mr. Ajay Prasad, respected DSP DEB, Mr. Sanjeev Sarkar, respected DSP Headquarter, Mr. Sandeep Sorkhel, respected SDO Bidhannagar, Dr. Vishwajit Panda, and all dignitaries, all of you are heartily welcome today. Now, this is the time to welcome my learned advocates who sacrificed their Sunday chamber for this conference, all the learned lawyers, mediators, and learned PP, GP, additional PP, and all the members of the bar, you are heartily welcome today. Now, the last but not the least, my backbone of this judiciary, my learned brothers and sisters, all the honorable judges, learned judges of this judiciary who supported me and stood beside me for organizing this program, I heartily all of you welcome today. To say a very few words about this program, I being a trained mediator, I am very eagerly waiting to hear the version and the speech of all the honorable members who are present over there to update myself and to clear all doubts regarding this mediation procedure, and I hope and pray this program will be a great success. Thank you so much.
Thank you, Madam. Now the program will be inaugurated by lighting the ceremonial lamp. Honorable Justice Tandon is requested to light up the ceremonial lamp with Honorable Justice Talukdar and Honorable Justice Shubhra Ghosh. I request District Magistrate North Parganas to join this lighting up of ceremonial lamp as well. Thank you, Lordship. Now, Honorable Justice Harish Tandon Honorable President of the committee is requested to deliver inaugural speech.
Thank you. Good morning to all of you. This is really one of the very momentous occasions that after the pandemic globally struck and it really increased the pace of the life considerably, and we have shifted to a virtual mode. Now this is the first time that we are now gearing up and resuming a normalcy and organizing a physical program. What I feel is that virtual is definitely a good technique where we can communicate amongst others or with each other. But so far as the face-to-face communication or discourse is concerned, I believe personally that it has some kind of a very positive impact, both psychologically as well as the physical interactions that really gives a good idea and promotes the purpose for which we organize those programs. I'm really, I would say that thankful that my brother and sisters at the bar, they have taken out a time. I know it's a good time for their chamber, meeting the clients, preparing the cases. But thank you that you have spared time for me at least, or to the mediation committee that you have come and participated in the program. I am also very indebted to my soldiers, which I believe they are the backbone of the judiciaries and they uphold the justice, that they have spared time to come here. I am also thankful to the administration, the DM and the SDO, the SPs and the DSPs, all who have taken pain to come here and participate in this program. I am also thankful to many other stakeholders of the mediation that they have really shown their keen interest in this particular program. And I believe that in an interactive session, we will have a very meaningful discussions on these issues, which would definitely shape it into a more firm stand than what it is today. I must be very candid to all of you that I was a lawyer for nearly 19 years and practiced in the court. Every lawyer has a perception. Whenever the client comes, whenever the other side, other lawyers are there representing the other side, always the tendency is to see that the matter gets settled. And if the parties can resolve their disputes with the help of the respective lawyers, I think that is the first and foremost thing every lawyer cherishes. Apart from, definitely the litigation is one of the other things which every lawyer feels, but the primary object is so that the parties may amicably resolve the dispute so that at least they can go back with some kind of a satisfaction in their heart and their mind that they have received the justice. It is absolutely a myth that once the lawyers they exercise this kind of a thing to get the dispute resolved, there is no other way or there is no other person who can do it. I think that mindset has to be changed. There must be some reforms that should be brought in the mind of all the practicing advocates, that the mediation as it stands now has a greatest of journey since the civilization known to us. I have been reading a lot of articles. Now it is all available on the internet portals. The earliest known civilization we know is about the Sumerians, Sumer, Mesopotamia. That was the earliest way. I was reading one article and I was really surprised to see that in those days also, the primary object of this developing civilized society, at that point of time, we can't say it was a well-developed civilized society. It was really evolving and developing the society in that manner. They have taken the dispute to a person or a group of persons they used to call as a maskim. The maskim used to just facilitate the, I would say, the disputing parties or the disputing persons, not only on a social war or a political war or a power war, but in many facets of the life, so that an orderly society may live and come up in reality. The role of the maskim was that they used to go to the villages where the litigants, if there are two persons of a different villages, they used to just travel to the villages of each person. They used to interact with the villagers. They used to just try to understand that what actually has made this particular dispute to come up between these two persons. And after that, they used to come and advise these litigating parties that what could be the best solutions you can explore of to resolve such disputes. That was definitely at the rudimentary stage, but can be said to be one of the facets of the mediation, where these maskims have really contributed a lot. I think the Sumerian civilization is known 4500 BC. I think the earliest known civilization. Look at the things that at those point of times also, the people used to explore the possibility of the resolution through a particular mechanism. And that was the best known mechanism, like discuss, dialogues, interactions, and opening up. What I feel is the biggest stumble block in the mediation is that both the litigating parties, the moment the dispute starts, they do not see eye to eye, nor they want to talk on any of such issues, and they have a sense of security, I do not know, must have been percolated or must have been assumed, that whatever will be decided in a conventional way of the adjudications, that's the court system. But I believe this kind of a stumble block, if I say, in between them, can be broken by way of a mediation. It's a psychology, human psychology, I would say, that the moment the person started discussing and there is a dialogue amongst themselves, if they just pass on that what is painful to them because of the act of the other party, at least that eases out to some extent, and that opens up the possibility of the amicable solution to such disputes through a mediation. As I already said, that every lawyer, when he is there, he always tries, but there are some unique techniques, and the myriad of techniques that really helps to ease out the parties and to open up and to explore the possibility of the mediation. I must be very candid that when I never say I have been elevated, I always say shifting of my position from one side of the room to another side of the room. I always believe in that particular theory. I never say that I have been elevated as a judge. No, it's a simple changing of a place. I was on that side of the room, I have come to another side of the room. So when I came here, so I had the same mindset that so far as the mediation is concerned, I believe it is of no use, it's a wastage of time. When I was entrusted with such an onerous task by the Chief Justice of the Calcutta High Court to head the committee, the Mediation and Conciliation Committee. And the moment I just started thinking and working on this particular concept of the theory of mediation, I find it's a wonderful tool. And it is absolutely misconception in the mind of, it was also there in my mind, of the lawyers, that if they have failed to resolve the disputes or bring the parties to a common platform, I think the mediator, who is also one of us, will make it a charisma. Can he do a charisma? Then I thought, no, there is a program which is being organized by the Mediation and Conciliation Committee at the Supreme Court level. There are trained mediators. The training programs are there. There are different, the techniques which are used by the mediator. And it is all based upon that particular experience which he gained or the knowledge which he achieved from those programs, that it can really help out in a very, very, very positive manner. We have seen many unconventional way of acting as a mediator in the past. But now, by changing times, it has also changed its course and have adopted new techniques with the changing pattern of the society. In early days, as we know, if you go to Israel, if you look at Israel, after the death of King David, his son, the Solomon, he took the throne, and he was known as the very witty person. And there's everybody knows about this story when before the King Solomon, the two ladies, they came and they fought over the child, and they're claiming that the child is her. The Solomon was absolutely perplexed at what to do, but he exercised that wittiness, and then he said, do one thing, when both of you are claiming the child, I don't know who is the real mother. I think at that point of time the science was not so developed that we can go for a DNA test and then find out. That was very easy now. So those days were a very tough time. It was not. Then the Solomon wittingly said, you make a half, make the boy into two halves, take one half and you take another half. The real mother will never allow her child to die. Definitely not. Then one of the lady immediately said, no, I do not want, let my child be given to her. I do not want to let him live. I do not want him to die. And that was, I would say, that is called a Solomonic wisdom. Many people say it's a Solomonic wisdom. But I say it's one of the way of taking a decision may not be in that sense as a mediation. It may be, somebody says it's like an arbitration. But it has some blending of a mediation because it gives us solace, it gives the peace to the solutions, and this is what one can perceive about the mediation. If you look at the distinction between the litigations, mediations, or the arbitrations, you will find a real differences how this works. So far as the litigation is concerned, it is definitely non-voluntary because the parties, they do not want. It is definitely a non-consensual because the parties have not, because that's the forum provided by the law. They have to approach it. May not be they are not willing to go, but they have to go. That's the phase, non-consensual. And it is an adversarial. This is what is the unique of the litigation, that's the litigation in the court. And if you go and see the distinction between this and the arbitration, that's a consensual, means sometimes non-volunteers, but it is also an adversarial. And if you look at the mediation, the beauty is that it is a volunteer, it's a voluntary approach by the parties, it is consensual, it is non-adversarial. This is what is the very unique and the substratum of the mediation concept, one has to understand. We belong to a country, so I would be failing in my duties if I do not refer some of the well-known facts and the events which happened in our country. It's a country of glory, it's a country of culture, it's a country of spreading these knowledge, everything. We belong to such a great country, so where it also happened. If we go to the age of Mahabharata, we all know that there was a dispute amongst the Pandavas and the Kauravas. They were ordained to go in a jungle or the forest to remain there for a pretty long time. And 1 year they had to hide. And thereafter when they came back, then they wanted that their kingdom should be given back. And one of the Kauravas, we know all, the Duryodhan, the name is well known to everybody. He was not interested. Then these Pandavas, they never wanted to fight because they feel that it is a fight with themselves as well and with their relatives. They do not intend. And curiously enough, I was reading one book which really the author have, in a very nice way, he was writing it, that the conversation of all the 5 brothers, that Pandavas with Lord Krishna. The Yudhishthira, as we all know, was a person who always believed in the dharma or the rule of law and never allow anything to act beyond that. So the rule of law or the dharma was that he told Krishna that we want an amicable solution, we don't want a fight or a battle. Curiously enough, this author have recorded the conversation of Bhim with Lord Krishna. Everybody is known about the character of a Bhim. He's a very strong man. He always want to fight. He always want to defeat the others. And he's a short-tempered guy. He will never believe. But this author has written that how the Bhim interacted with Lord Krishna. And he says that even a Bhim does not want to fight. He was saying that the Bhim says that, look, the Lord, I know we can defeat. We have the best warrior like an Arjun, like me, and the other persons who will come and join. But I believe that ultimately what we will gain the flesh, the dead flesh, spreading everywhere, and then what we will do with this kingdom. That was something which is absolutely unlike the character of a being, or it was absolutely a different. But I was really amazed after reading that at least the being has come out, and he says that there must be an amicable solution to the dispute. Arjuna was always, as you know, that he doesn't want to fight. Even in a battle, he says, I can't take my bow and arrow. I can't hit at my, the elders who have brought me. So that is what we get, that the version of this particular Gita that was there, told by Lord Krishna at the battlefield. But Nakul and Sahadev, definitely they were there. But the character of the Bhim was something very amazing. And the Lord Krishna, he decided to really act as a mediator. He went to the Hastinapur at that point of time. And there is also, the author has also said many things about the conversation which was there. And the conversation as with the Duryodhan was that he was always absolutely stumble block in all obstacles. He was creating an obstacles in every sphere. Even as the king Dhritarashtra, he was very keen to give them the kingdom. Yet he told, the author has written that the Lord Dhritarashtra, the king Dhritarashtra said that I can't convince my son sorry, if he says no, I have no authority to say yes, though he was a king. So that was an irony, and the Lord Krishna really acted as a mediator, and that he tried to pacify and try to avoid that great battle of Mahabharata, and that is what I think the mediator role is. He is a facilitator, he acts as a catalyst, so that the parties, they can come on a common platform and can take a resolution and can decide whether there is a possibility of the end to a particular litigation. Many of the philosophers and the thinkers, as we know in the past, even an Abraham Lincoln, who was himself a barrister, he said that it is better that the parties to resolve their disputes through a mediation or through whatever the medium, whatever the other resources which are available, instead of going to the litigations, which should be taken as a last resort. There are many legislatures that have come up now. One of such was the Commercial Courts Act, which says that the approach to the court is somehow brindled or impeded unless you take recourse to a mediation. That is, we call it a pre-litigation mediation. I think the Consumer Protection Act has also incorporated some of the provisions. Now, very unique thing is coming in a recent past. The bill is still pending in the Parliament. This is, they call it a Mediation Act, and the mediation bill is pending. And there is a lot of, the discussions which are going on, the views and the suggestions are invited from every nook and corner of the country so that it can do it. What I was going through a bill, I find it a very unique thing that I perceived from reading of that particular bill was. Because there are certain provisions which they are trying to bring it into it to make it more, I would say, a legally binding document than, though there is a freedom of contract, no, that once the contract is fructified by signing and executing by the parties, it will become a character of an award and enforceable like an award. That's a very unique thing, because I believe the concept and the theories of mediation does not propagate nor garner such theories, but still this is on, I think it's on there, and it's the Parliament who has to think. And I coined this particular phrase, if I am not wrong, that if this act come into the reality, the word mediation and the arbitration has to be blended together and may be called as a med-arb. It's a mediation come arbitration, med-arb. That's, I coin it in that sense. We have to understand in those perspectives. I really beseech to all the judicial officers who are present there that you are one of the pioneers, may I say, that who can really propel this particular mediation by making a reference so that the parties, at least they can go and see that what the beauty it has. Equally, the member of the legal fraternity, they are also responsible for this. It just struck in my mind when I was honored with the small pot of trees. I believe this is an honor, and I take it as now where the mediation stands in a sapling state, we have to make it a full-grown tree. And without this, it cannot, without all of your contribution, it cannot. Again, there may be a lot of arguments on this, but I believe is that if you look at the tree, what is visible to us is only the trunk and the crescent or whatever the grandeurs it has with the flowers, trees and all, everything. What is not visible is the root. If the root is weak, not even a trunk nor even its glory which is available can sustain in the storm. But if the root is very strong, it will withstand and definitely will make the entire thing to flourish. It cannot. I believe the roots are the mindset of the litigants, the mindset of the lawyers, the members of the bar, and the mindset of the judicial officers who are referral judges, that they have to find out that what are the cases which are capable of being resolved through an ADR system. And the moment they find that there is a possibility, then and then it is possible that the mediation, what we are thinking today or what we think in future, that will come in reality. Equally, the mindset of the lawyers will also be there, that they should welcome this particular decision of the referral judges, and they should participate in the mediation process with an open heart and a mind. Definitely, the lawyer is supposed to take care of the best possible, the solution in favor of his client, but still somewhere it has to see that at least the peace is restored in them. I give a very simple example in commercial matters I always give. When two merchants, they are at loggerhead and they wanted to litigate on a particular recovery of money. What they say is, somebody may say that yes, there is a contract. As per the contract, I have supplied the materials, and now it appears that he is not paying money to me, which he has agreed. The other says that I find that there is a contract, but the price has gone down considerably in a recent past, because this contract was entered into 5 years back, and now the price has gone down. So there is a clause which says that in case of an escalation or a declining in the price, that has to be amicably and mutually resolved between the parties, and therefore he is not interested in invoking that particular clause. These kind of a litigation, what has happened? The first thing is that the money gets both the merchants, they lose the prospective sellers and the buyers, and thirdly, they lost faith on each other. This is what the three things that happens in a commercial matter. So this mediation, if it is done, what will happen? Sometimes it so happened that they were claiming a lot of interest. If the money comes to them immediately, they can roll it out at a frequent levels, and the amount of interest which they are losing or they have decided to lose, they will find that they earn more than that. And if the money gets stuck up at the end of 10 years or 15 years, if they get a 6% interest, I don't think it's a commercial wise decision. Whereas they can buy a goods of that particular value and they can supply at the profit of 20%. So they can earn more if the money comes to them immediately. So I think that is the thing you all must keep in your mind. And lastly, I must say that our father of the nation, Mahatma Gandhi, has also said in the light of the Abraham Lincoln that you, the lawyers, will not lose your fees nor lose your livelihood, but you will gain the confidence of the society. You will bring the peace to the society, and you will still be capable enough to sustain for your livelihood. Thank you. Thanks all.
Thank you, Lordship, for your message. The message is loud and clear that our judicial officers and other stakeholders have to act as an agent of change and also an agent of peace. Our role is cast out. We have to take again the responsibility to make it a grand success. The sapling will grow into a tree, of course. We will go back home with that impetus to bring in that change. Now next I would request His Lordship Honorable Justice Talukdar to express His Lordship's views on mediation.
Good afternoon to all esteemed guests and participants on the dais, esteemed guests and participants of the dais. I am grateful for the opportunity to make some short and quick points today at this seminar. Essentially, we are here to carry forward the message of mediation. And mediation is not an option. As my senior brother, Justice Tandon, aptly put it, that mediation is a way of litigation, a structured litigation. And we need to introduce that structure in our practice. It's a common sense application of law. And I think most stakeholders are present here. We are from the judiciary, the lawyers, the administration, the police, and we all need mediation. So I begin this common sense application of law from a small story which some of you must have come across, some of you may not. Two gentlemen were traveling on an aircraft. One person was very learned, holding a PhD degree and others. The other person was a small-time trader. So the learned person told the second man that let us have a question and answer session. That since I am learned, I'll ask you a question. If you answer, I'll give you 100 rupees, and vice versa. If you fail to, if you answer, I'll give you 100 rupees, and vice versa. You ask me a question, and if I answer, you give me 10 rupees. Or if you fail to answer, you give me 10 rupees. The bargain was question and answer, 100 rupees and 10 rupees. So the other man agreed. The learned man placed the question about some rocket on the moon. What was the name of the rocket? This man, the second man, could not answer it. And, well, the first man had to give 100 rupees. That was the bargain. When the turn came for the second man to ask the question, he says, tell me the name of the animal which goes up the mountain with 4 legs and comes down the mountain with 3 legs. So this learned man could not answer this question. The animal which goes up the mountain with 4 legs and comes down in 3 legs, on 3 legs. So the 100 rupees which the second man got, the learned man could not answer. He gave him, as per the bargain, 10 rupees, the second man. The learned man says, very well, I could not answer. You tell me that what is the answer to that question. The second man says, I do not know also, take another 10 rupees. So that is in effect the solution to the issue, a common sense solution. Mediation in fact is a situation where we have to gradually recognize that it is getting structured. In fact, it is a replacement, as the phraseology used by my senior brother, med-arb. Of course, the mediation part is coming later. The arbitration part has come first. If you all remember, the Arbitration Act began in 1940. Then the second act came in 1996, possibly an amendment in 2015. So it has taken these very many years for arbitration to mature. Mediation, as far as Bengal is concerned, as far as we are concerned, as far as I am concerned, began with our erstwhile Chief Justice Radhakrishnan Nair initiating a full steam effort into mediation from 2017. My learned senior brother Justice Tandon has headed that effort from 2017. We are 5 years down the line now in 2022. Our honorable judge, our learned judge, Anirban Das is present here, who is now no more the Registrar of Mediation, has handled the mantle to Judge Vishwarup Banerjee, but he was the engine in the mediation effort for the last 5 years. So last 5 years we are doing what we are doing now. This is the third regional conference, face-to-face meeting after the pandemic. There has been an internet book fair where we had a stall. There is a mediation fortnight. I'm thankful to one of our our extremely erudite mediation functionary, Subhashish Mohri, who has been also the hard work behind everything that we show before you, we produce before you. We have learned mediators, but the question is that we are stakeholders here. I believe there are banks, there are insurance companies, there are lawyers, and there are referral judges. So if all of us, number one, do not get trained, we don't understand the niceties of mediation. Number two, if all of us, only if we get trained, we can refer. Number three, we are going to get clogged with pendency. Courts are being clogged, the administration is to be clogged, the police stations are likely to be clogged. So clogging will earn the man on the desk a bad name, one day or the other. So we have to declog, we have to clean the drain pipe. And for cleaning the drain pipe, we have to have mediation as a form of settlement. We have to introduce, as Justice Tandon said, a mindset where if you start a dispute, you also have the mindset of settling the dispute. And lawyers are extremely important in this process because they handle the litigation. And possibly one thing keeping them away from influencing or persuading clients to refer mediation is that what do we do for a living then? Where do we go? But the whole issue is, in other metropolises perhaps, and of course out of this country, mediation has adopted a structured practice. There are chambers of lawyers wholly devoted to mediation. So the whole thing is you make up in turnover and ultimately you bill by the hour if you are thinking of where it is going to. I would love to refer to all of us who are here from 2017 down to 2022 as the first generation of mediators of the training process. So we would request the banks, the institutional, that there is a clause in the mediation rules which allows you to train experts having a certain degree, a threshold qualification. So please send people for training. Only then you can tell your customers. The point is, you are answerable to whichever authority in your bank, but in case you settle, the court adopts your settlement and passes an order accordingly. Therefore, the courts are involved ultimately in your settlement. So this is the process where I would very much like to add another aspect which Justice Tandon mentioned, and I have a note which I must say that there are the legislature at the appropriate level is thinking of it. Because one aspect is the laws are no more mystical. I'm sure the district magistrate and the administration of when in our generation we sat for the Union Public Service Commission exams, a law paper was a paper full of mystics. Answer this, answer that concept. Law is today being broken down by the legislature to reach a common man, a client walks into your chamber, he knows what he is walking in. He has read the Bare Act, he has read that section. So law is no more mystical. Similarly, doctors are no more mystical. Only in rare surgeries inside the operation theatre are they what they are. So in this context, when mediation is finding its way into the Industrial Disputes Act, the Civil Procedure Code, the Companies Act, the Micro, Small and Medium Enterprises Act, Section 89 of CPC, Section 14(2) of the Hindu Marriage Act, thank you Subhashish Mohri, Section 32G of the Real Estate Act, the Commercial Courts Act, everything that is happening in courtroom, everything that has to happen with any law has a mediation clause. And the question is, clients have read it, have opened their laptops, have come, are equipped. Only thing is to get them informed and participate in it. So, the last word that I would like to add here today is that mediation is not going to be an academic exercise. The purpose of this seminar is that it is a potent, practical solution. So the question is, it is not going to be an option anymore 5 years down the line. Arbitration Act of 1940, today we refer to arbitration as a not so fast process of arbitration because that has multiple stages of things. But mediation is based on consent, So there are no challenges if people consent, and there is no harm if banks, institutional investors, institutional stakeholders and others can settle their claims across the table. They'll possibly save money, and lawyers will try to earn more through added turnover. Thank you very much for this opportunity.
Thank you, Lordship. We understand that mediation, actually that concept exists in different statutes, and we have to work to just reduce the burden of the court through this mediation process. Mediation is not an option, it's now mandatory, and it's going to be more and more important in the coming years in order to reduce the burden of these court matters, court records. Thank you, Lordship. Now, I request Srimati Shutopa Sannal. Srimati Shutopa Sannal, learned advocate, High Court, Calcutta, and a trained mediator, says, who has successfully conducted numerous mediation matters and ADS Center of High Court, Calcutta. I would request her to share her wisdom and experience on this subject.
Thank you for giving me this opportunity to speak before you all. Very good morning to all of you all. I would thank Honorable Justice Harish Tandon, who has given me this opportunity to come up before this august gathering in this occasion and to speak some of my experience. And I would also thank all the distinguished guests, my Lord Justice Talukdar, my Lord Justice Shubhra Ghosh, and every distinguished guest and my fellow advocates who are present from various district courts. It was one of my experience during this COVID tenure that I really volunteered to get myself into the course of getting trained as a mediator. Now, when I decided to get trained as a mediator, the first thing which really occurred to me was that, okay, very well, now that it's pandemic, we are doing everything online, we are not meeting people, so at least this will be a way out, a window to get out of the boredom, to meet people while we are getting trained during this 40 hours training course, which was organized by MCPC Supreme Court. Now, during this course of training, I must say, at the very inception when I started this training session, my mindset was absolutely a hardcore adversarial litigant, counsel, and I was no way having any sort of ventilation on the issue that I would really espouse the cause of mediation at all in my practice life. So that was it. That was the stubbornness which I had when I entered this course. And during this 40-hour course which I underwent, I must tell you all that it was a life-changing experience. Because then I really thought to myself that yes, there are certain things. There are certain things which we had actually espoused all our lives. Even when we were children, there were issues where we wanted something which would be the best to our interest. And at that juncture, it so happened that we were actually given the choice and options so that we can choose the best and lose nothing. And that was done by our seniors in family, friends who acted as a mediator. We never knew this concept of mediation then, but we got adapted to it, customized, and we did practice. We did practice, it was ingrained, and we never realized that this is itself the concept of mediation. While undergoing training, I really felt that yes, it is. We had done it, and we had not done it once, we had done it repeatedly. And then I also pondered that being an advocate, we had actually espoused the cause of our litigants and tried to get their matter eased out by way of settlement outside court at times by way of filing applications like 482 and then file an application wherein after the outside settlement has occurred, we file an application asking that this has already been compromised, so let there be an order in terms of such. There had been other forums where he had applied for expeditious disposal in order to ease out the traumas of the litigants, because I must tell you, when a person comes before the court, definitely for us advocates it's good because we earn our material instructions, but for others who are really fighting it out the hard way, It is not always a very pleasant job. So they themselves have those sufferings, and they are compelled. I won't say they are accustomed, they are compelled to get into such sufferings because they don't have any other options but only one recourse as is provided under the law. So this is what it is, and this is how it goes. Then finally I became a mediator after the 40 hours training, and various things was encoded into my head which I had never had before that session. But after that session, I really understood that we, the advocates, we can really fructify solace in our professional career if we can really head on for giving something to the litigants or those who think us to be their God by approaching us for a remedy, and we can channelize them to such motivations of getting their issues sorted out by way of mediation, if at all that is permissible under the law. Because there are definitely certain litigations where we don't get the option of settlement, where we cannot actually advise the client to go for a settlement because that's a hardcore judicial process which has to be undergone and there is no other option. But there are certain cases definitely where we have that option, and I think being an advocate, if we do exercise such options, we do not lose in any manner, believe me, in our professional life. And this is what I had experienced while acting as a mediator as well as an advocate, because being an advocate was my first priority, and I had been a advocate before I became a mediator. But after I stepped into the zone of mediation, I felt that we can give a different definition to our professional career if we really adopt that mediation is a tool where we can really expedite disposal. We do blame, many a times we do blame that the benches are slow, the judges are taking much time to dispose of matters, so on and so forth. But we do not realize that we really cannot discount our own responsibility of also advising our clients to reach an amicable settlement if otherwise that is feasible, and that can be done for the better interest of the litigants. Because you must remember that it is these litigants who will actually give you that which you are otherwise wanting as a professional. So if you have to give relief to these people, and if that can come by way of adopting this tool of mediation, then why not? And since I have been asked to share one of my experience, I must tell you, I had the privilege of trying to mediate on several issues, commercial as well as domestic violence and other matters. But this is a very strange thing where I really felt that how mediation really had helped. This was a long-standing dispute between a couple, and they had their loggerhead reservations. They wanted to do certain things, and they were in no way ready to compromise or come to a common point, because they knew that they had done everything that is right according to them. Now this according to them is basically the point which we mediators, after being trained, we were learned to just get hold of, and that is what we were told is lateral thinking. Because if we can find out what is the common point which is really in dispute between the parties, we can really try to give them some suggestions to facilitate the entire dissolution of dispute, and so that both these people can really end up happily and they can just get out of that mediation center with a very happy ending. Because I tell you, it did happen. These two people who were fighting this litigation, they had gone before the apex court, before high court, and definitely before the lower courts, their suits and their criminal proceedings, so much and other so many forums they had availed of. But when they really came down to mediation on being referred from high court at the stage of appeal, and when I could get the chance of having a private focus with them, trying to find out and sort out what is really their difficulties and what is the dispute, I found that it is a matter of sentiment and ego which was the factor which had acted as a catalyst and has catapulted this entire dispute and wasted a 20-year life of these two people. It's very unfortunate. And we had, in effect, given them advices file this application, file that application, they filed it, they fought it. We definitely gained materialistic values out of it. But tell me something, being an advocate, do we really want to just subside us or think only on the material things? We also need solace. We also need that satisfaction that yes, being an advocate, we have done something good for some people at large. So after all, we are also officers of court. Please do remember, all my brothers and sisters who are present, who are practitioners and who aspire to reach the top, definitely you all can. But I tell you something, in one of the seminars where I heard Mr. Nariman speaking on international arbitration, he himself espoused the fact that mediation and conciliation is but a tool. Arbitration is the process and mediation is the tool. So please, I would welcome all of you all. The judicial officers are doing their best they can to refer matters. But when these matters are being referred and we are the advocates of their respective clients, please do try to also blend their mind to such an extent that they also are exposed to this idea. Because if you say that, look, kindly do not cooperate with the mediator, kindly do not cooperate in the proceeding because that will yield you no benefit, then in that event, even despite all efforts, we the mediators will become Lord Krishna and Mahabharata will actually happen. So please do not do that. Thank you so much. Thank you everybody for this occasion and thank you once again.
Thank you, Srimati Sannal. She actually seeks to define the role of the learned members of the bar. How the learned advocates can take part in successful mediation, what the role should be. Actually, she shared her experience and we got enlightened and inspired by her speech. Now, it's time for interactive sessions. I request Dr. Subhashish Mori, our officer in charge of the committee, who is also a trained mediator, to act as moderator in course of the interactive session.
First of all, I thank my learned member secretary sir for giving me this opportunity to conduct this session of the program. May I most humbly beseech the permission of your lordship to start the interactive session. Obliged, my lord. I would like to request the volunteers to go into the sitting arena with two cordless mics and stand at the two farthest ends of the room. And I would also like to request one volunteer to Mike, please give at least two cordless mics to the bench of their lordship. So the question answer section or the interactive section goes on like this. Before starting, I would like to give you the thumb rules that all the distinguished guests, participants and invitees, all of you are most welcome to participate in this interactive session. Please raise your hand sitting at your respective chair, seat. Please raise your hand first and let our volunteer reach you and hand over you the mic. Once you have the mic in your hand, please stand up so that you can be spotted in the crowd, so that you are more visible in the crowd. And then first introduce yourself and then put the question to their lordship. Wait for the answer to come and then you may proceed with your second question, if any. And once you are done, please hand over the mic to the volunteer. And last but not the least, what I would like to mention, that please confine your questions within the periphery of mediation and alternative dispute resolutions only. Thank you. May I request you, all of you, to start and by raising your hand, please. Thank you.
Very good morning to honorable judges present here and all the learned friends, seniors. My name is Vivek Sharma and I am practicing at Bidhannagar court. My lordship, I have very recently I faced a issue regarding this mediation only. What happened was a lady, there was a matrimonial dispute and multiple litigations were filed by both the parties at Bidhannagar court in 2018, and in 2020 the matter was resolved amicably. There was a mediation and accordingly the matter was disposed of. But later, just after 6 months, the opposite party violated the terms and conditions, whatever was there in the mediation. So after that again the litigation started. So it's 2022, but the matter is not even being heard. So I have a question and I want to know that if there can be any alternate provisions where specially in case of failure of mediation the matter can be dealt so that we can convince our clients that if a mediation fails there will be fast solutions of the problem. If there can be any such provision or any solutions.
There are two things we must realize, because once you participated in a mediation process, then you are participating with a conscious mind, with the open mind, and you know the best interest of yours. And the moment you enter into the agreement before the arbitrator, before the mediator, then in that event, that agreement is capable of being furthered if anybody violates. We are not going to say that what should be the course, because it is still regarded as an agreement. And you know, if there is a violation of an agreement, then what are the remedies which are provided? There lies the difference, I tell you, because once the party consciously entered into the terms and they executed the agreement by signing it, there may not be any reason to resile therefrom. There may be certain circumstances that may compel the repudiation, that may compel some kind of a steps to be taken against the particular terms and conditions of the agreement. But there, the role of the lawyer is very important. How to, I think, weed out those impasse which has been created in the mind of one of the litigating parties. There are varied circumstances. There may be varied circumstances for which. That's why I said that till this time, the mediation, the concept of the mediation is that it's an amicable solution which has been sorted out by the litigants themselves and reduced in the form of an agreement. It is nothing but a form of an agreement which binds the parties. And I was just, in my deliberation, I have already highlighted that there is a mediation bill which is pending in the parliament. It has not come up as yet. But there, they are trying to inculcate a particular provisions that what would be the nature of those agreements. And I believe, if I am not wrong, I think Ms. Sanyal has read it more in a more, the critical manner of this. I think there is a provision which says that it will partake a character of an award, capable of being executed as an award, as a decree of the court. And you know the limitations so far as a decree is concerned, how far the challenges can be made. I think let that day come. We are very hopeful. If it becomes a reality, we can do it. But only thing is, your role is very important. If they have come up, you can't stop. That's the process of law.
I just want to add to what my learned brother said. Your question can be divided into two parts. The first part is the first dispute. That was mediated. That was consented. That became an order of court. So after that, if there is a fresh dispute or no, that will be the question. You go to court and tell the court that he agreed to whatever has happened. They block the second release. The question is, you have a ready-made solution in your hands. Use that. Go to court, say he has agreed to the award or she has agreed to the award, the consent order. You cannot escape, you cannot come out of your consent and block the second release. Be practical about the whole situation.
Right, sir. Thank you very much. Sir, just one more thing. The practical problem which we face, because there is a huge pressure upon our judicial system, that is something we cannot do anything about it. But my suggestion, or what I was meaning to say, that if there can be some special provisions in case of failure of mediation upon our...
No, there are two concepts. One is a failure of mediation means that the mediation has not fructified into a positive result, and another is it turned out there was a positive result and there is a further, I would say, the dissension or whatever, the dispute that has cropped up. So these are the two things. Once the mediation is successful, parties have executed the agreement, they have decided the terms thereof. This is one, that's an end of the situation. Further one is a further cause of action for which one has to understand.
Mention that it is not mandatory that you should ask the question in English language only. Feel free to ask in other vernaculars. I mean, যদি আপনারা বাংলায় প্রশ্ন করতে চান, হিন্দিতে প্রশ্ন করতে চান, please proceed. And especially for our trained mediators, I can see them here in the venue. Please put your questions. If you are facing any issues, please put your questions to the Lordship. Thank you.
Thank you and regard. I am Madhuka Devrai, mediator, trained mediator from 2011, Barashat district Tosai. So my question is that, sir, we are facing one thing that according to Mediation Rule 2006, 25, Rule 25, that learned court, after matter referred to mediator, one matter is settled, and that after returning and before a referral court, learned court passes decree. That is, my point is that sometimes as a lawyer they are facing that cases are not disposed of or decreed. What to do? Actually, in mediation, we are used to say that according to Rule 25, 2006 Mediation Rule, learned courts are can pass decree, but facing learned lawyer are facing that they are after mediation, specifically matrimonial suits and specifically cases which are filed under Section 13 HM Act or Special Marriage Act, decree for divorce, that cases are referred to mediation. Sometimes their conjugal life lead may not lead. They want to decree of divorce. That case facing, and at the same time we are also facing that mediator, before mediator we write down the agreement, but we are agreed for decree of divorce, but at present learned court are not, we are not giving that. Matter is not disposed of and giving the order that you take steps. These are the main important question that they are facing this problem. We are actually, we are know that regarding the section Rule 25, matter can be disposed by part, by complete, that decreed, matter can be decreed as per agreement, if agreement are legal. This is my question, sir.
It is more a subjective and a satisfaction than satisfaction. Because Rule 25, if you look at it, the moment the settlement is has arrived between the parties, it is the duty of the referral court to fix another date within a time frame, because the time limit is also given. And then the notice also says that it should not go beyond a particular time frame. What I find is that the language is in subsection 1 or sub-rule 1 of rule 25 is somewhat, I think, akin to order 23 rule 1, 2 or 3 of the code of civil procedure. The parties, there is a freedom of contract. There is no doubt about it. There are catena of judgments which says that the freedom of contract lies with the parties themselves. But in the guise of a freedom of contract, one cannot enter into a contract which is against the public policy, which is against the law. If there is something forbidden in the law, even if the parties they have agreed upon a particular term, it is not an obligation on the part of the court to accept that particular, the mandate of the parties and to put just a rubber seal to it. If there is some kind of a subjective satisfaction which is required to be gone into by a referral judge, then certainly it is within his domain to see into it. If the law forbids, if the law says that certain course of actions are only required to be taken, then in that event it has to be taken in this perspective. It is a very grey area, I tell you, madam. There are a lot of discussions which are going on. I had a lot of points on this issue. What is required to be done? I think let the judicial side decide first, and then that would be a landmark for them to follow in future.
Yes, sir.
The only thing is that once the settlement has come, I request to all the judicial officers, please look at the time limit within which you have to act. You have to immediately issue a notice which should not exceed beyond 14 days. You'll have to bring the parties, apply your judicial conscience and the mind, and you will find that the agreement is very onerous. There is no problem in this regard, and it is not opposed to any kind of a statutory provisions or the public policy. Public policy is also a very vague term, madam.
Yes, sir. Yes, sir.
It changes. It changes. Public policy changes with the polity.
Yes, sir.
So you can't bring it within a Euclid's theorem that it has to be done in this fashion. No, it's it is a changing concept. So one has to find out. The most hilarious task, humongous task, I must say, on the part of the judicial officer to decide it. What is the public policy? So let them. I think they are sensitized for that purpose. We have organized this program for this purpose. So they must adhere to what has been given in Rule 25 of the mediation rules framed by the High Court. I hope that they would do it.
Yes, sir.
Your Lordship, I am Arup Kumar Mojumdar from Bidhannagar Bar Association. My part of the question is divided in three. First, what may be the watershed difference between the mediation and the conciliation and arbitration? First. Second thing, sir, if not, as we heard that Mediation Act is going to be discussed and passed later on in Parliament. My second question is, as per Conciliation Act, there is some provision for giving the agreement between the parties before the conciliator. And my question is that if the conciliator or the mediator give the final settlement nod for the settlement of any dispute, if there will be a legal sanction for effecting it, as my brother Vivek has told his practical experience, if there will be any legal sanction for effecting the order of the mediator. And my third question is that, sir, whether any procedure like in court, like filing WS or information or evidence, whether it may be, whether it should be followed in due course in the mediation process also, sir. That's my question.
Sir, with the deepest of humility and the respect in my command, I think I have, while delivering, I have indicated that what are the distinctions between an arbitration and a mediation and a litigation. If you look at that particular distinction, the first distinction is, now I'm coming into arbitration and the mediation. The first distinction you will find, in case of an arbitration, it is consensual, because the arbitration starts with the consent of the parties. It can't be, unless there is a agreement, arbitral agreement, you can't. It's a consensual, but it is adversarial in nature, because the arbitrator really decides the disputes on the basis of what has come up in the evidence and what the pleadings of the parties are. Mediation is definitely not an adversarial. It's a non-adversarial, it's a consensual, it's a volunteer. Arbitration may not be a volunteer, it's a non-volunteer, because at one point of time the parties entered into an agreement. If the dispute comes, they have no choice but there will be an arbitration. So it's a non-volunteer. Also, they may not choose to go, but they are bound to go. Like a litigation in the courts is a non-volunteer. The parties may not intend to go to court, but they have no other option but to go to the court. They are compelled to go to the court. So this is what is the mediation. Mediation cannot be equated with an arbitration, which is an adversarial in nature, where the importance of pleading is there. One has to plead his case, one has to defend his case, that particular claim. So mediation is definitely a non-adversarial, where all the parties they go, it's a private, confidential. Confidentiality is the hallmark of the mediation. Whatever is diverse before the mediator, you can't use as a piece of an evidence in the court of law. If somebody uses this, he will be penalized. That's the very, I think, the first factor or the first ingredient of the mediation is the confidentiality. So this is never, please do not treat the mediation as an adversarial litigation where the claim is to be filed, the defense is required, pleadings are required. No, definitely not. It is never. I think the second question which you put was in relation to
legal sanction.
Legal sanction. As I have already said, so far as the mediation, now we have been working under the mediation in terms of section 89 of the Codicil Procedures. The first time, I think, the concept of mediation has been incorporated therein by way of an amendment in 2002. So it has not come up in a full shape of a statute. As I have already indicated, I was placed with the mediation bill, which was really placed in the floor of the Parliament, and now the committee has been constituted. They are inviting a lot of suggestions and the amendments or something incorporation that is required in that particular act. Unless that act is passed by the Parliament and this bill, I think, and transformed into the act, we have to see. That's why I coinage a particular expression, med-arb, because I find some kind of a blending of an arbitration concept into a mediation, because the agreement would be treated as an award and capable of execution. So this is what I believe is coming up. Till date, it has not. There is no difficulty. It is a consent, or it is I would say, the decision of the parties which is required to be respected in this regard. And the third, I do not know.
I told that I asked that whether the agreement between the parties are necessary, compulsory in the mediation.
That is required, because mediation ends the moment the parties agrees and signs the agreement. Then it comes to an end.
Honorable Justice Tandon Sahib, Honorable Justice Talukdar and Madam Ghosh and other judges. আমি লার্নেড মিডিয়েটর শ্যামল কুমার বিশ্বাস, বনগা কোর্ট। আমি যেটা প্রবলেম ফেস করছি, আমাদের বনগাতে লিগ্যাল এডের ঘরেই আমাদের বসতে হয়, এবং সেই লিগ্যাল এডের ঘরে বিভিন্ন এলাকার আমাদের সাব ডিভিশনের বিভিন্ন লোক আসেন এবং যখন তখন ঢুকে যান। আমরা যখন বসি নিয়ে, মানে বোথ সাইড নিয়ে বসি, বিভিন্ন প্রবলেম নিয়ে যখন বসি, তখন দেখা যায় একটাই দরজা, যে যার মতো ঢুকছে। আমরা একটা সেটেলমেন্টের দিকে এগোচ্ছি, তখন পাবলিক যে যার মতো ঢুকছে তখন সেটা আমাদের ডিস্টার্ব হয়। একটা মীমাংসার জিনিস কাছে এসেও অমীমাংসা হয়ে যাচ্ছে, এই জন্য আলাদা ঘর দরকার বনগার ক্ষেত্রে আমি মনে করি। আর একটা ব্যক্তিগত ফেস করছি, সেটা হচ্ছে 65 কেসেস আমি মীমাংসা করে অ্যাপ্লাই করেছিলাম অনারিয়ামের জন্য, কিন্তু আজ পর্যন্ত আমি পাইনি। কেন, কী জন্য আমি বুঝতে পারছি না। এই দুটো বিষয়ে আমি দৃষ্টিপাত করছি।
It is more a grievance than a question. We will definitely take care of your grievances. We will take a decision. We'll take a stock of the matter from our secretary. We'll definitely take care of that.
থ্যাংক ইউ। না, দুঃখ কিছু না, অ্যাকচুয়ালি এনার্জি লস হয়ে যায়, মানে কাজের গতিটা থেমে যায় আর কি। সেই জন্যই এরকম বলার সুযোগ পেলাম, এরকম পাই না আমরা।
না না, খুব ভালো লাগলো, মানে এটা দরকার আমাদের নলেজে আনার জন্যে, না হলে তো আমরা তো জানতে পারবো না। তো সেই জন্যে দ্যাটস ভেরি নাইস, মানে খুবই ভালো আপনি যেটা আমাদের নোটিশে নাম নিয়ে এলেন।
আমি
নিশ্চয়ই দেখবো আমরা, ওদের কাছ থেকে চাইবো এক্সপ্লেনেশন যে আপনার 65 আপনি একটা মিডিয়েশনে আপনি করলেন আর একটা আজ পর্যন্ত দেওয়া হলো না।
4 বছর আগে বিলটা জমা হয়েছে। আমাকে বসিরহাট কোর্টেও পাঠিয়েছেন, সেখানে আমার নিজের গাড়ি তেল পুড়িয়ে আমি গিয়েছি। সে আমাকে সাহেবরা বলেছিলেন যান বিলটা দিয়ে, মানে ওটা করবেন, আমরা পে করে দেবো। কিন্তু 4 বছর কোভিড শেষ হয়ে গেল, আমার এটা কেউ খোঁজখবর নিল না, যার জন্য বনগাঁতে লান্ডেড আমার যারা সাহেবরা আছেন বলেন যে আপনি এত ঝিমিয়ে পড়লেন, কিন্তু কী ইন্টারেস্ট আছে? আমি 4 বছর আগে কাজ করলাম, আমার গাড়ির তেল পুড়িয়ে গিয়ে এদিকে সেদিকে, আমার কেউ খোঁজখবর নিল না। এখন আপনারা বলছেন তাদের অনারে আমি বসছি ঠিকই, কিন্তু এই বিষয়টা তো কোথাও বলতে পারছি না বা কিছুই।
না না, থ্যাংক ইউ, একদম নিশ্চয়ই আপনার গ্রিভান্সটা খুবই গুরুত্বপূর্ণ। আমরা নিশ্চয়ই দেখব, কোনো ব্যাপার নয়। আর যদি কোনো প্রবলেম না থাকে ডেফিনেটলি আপনারা নিজের পকেট থেকে খরচ করে আপনি গেছেন, এটা পেট্রোল পুড়িয়ে, এটা তো ঠিক নয়। দেখবো, নিশ্চয়ই দেখবো।
থ্যাংক ইউ।
Good afternoon, learned honorable judges. Sir, I am Torun Dotto, representative of HDFC Bank Limited. One of my question from bank, we can refer pre-litigation matter before the mediation camp or conciliation camp, wherein no such legal activity going on by the bank, delinquent customer.
আমার তো কোনো অসুবিধা আমি মনে করি না। প্রি লিটিগেশনে সবসময় দ্য পার্টিজ ক্যান এক্সপ্লোর দ্য পসিবিলিটি। অসুবিধা কোথায় আছে? আমি তো কোনো বাধা মনে করি না। আপনাকে বলি, ইন আদার স্টেট কিন্তু দেয়ার আর সার্টেন অর্গানাইজেশনস অর দ্য ইনস্টিটিউশনস, তারা কিন্তু দে আর ডুইং দিস মিডিয়েশন।
We are already referred to post-litigation matter.
নো, এটা কোর্ট অ্যানেক্স লিটিগেশন। দেখুন, কোর্ট অ্যানেক্স মিডিয়েশন একটা জিনিস, আর একটা কোর্টে যাওয়ার আগে একটা মিডিয়েশনে, দ্যাট ইজ আ প্রি লিটিগেশন মিডিয়েশন। আর আমি এটা আরও বলতে পারি যে প্রি ডিসপিউট লিটিগেশন, বিফোর দ্য ডিসপিউট রিয়েলি ফ্রাক্টিফাইড ইনটু আ ডিসপিউট, সেটাও কিন্তু ইউ ক্যান অ্যামিকেবলি ডু ইট। অসুবিধা কোথায় আছে?
Sir, I am Alok and I head the legal for India's biggest e-commerce company. Pardon, sir?
Your full name, please.
Alok Pal. And I head the e-commerce for the company which does a business of a click of a button. We sell aircraft, we sell tea, we sell anything on earth. My question is whether, sir, you recommend to have a clause for mediation in the commercial contract when we sign between the parties, which would help us to perhaps to pitch into the mediation, whether you recommend that. And the second question is, how do you distinguish on a line of conciliation and mediation? Thank you, sir.
প্রথমে আবার I must say that so far as mediation is concerned, it is absolutely distinct and separate from arbitration. Arbitration definitely originates on a consent of from a consensual jurisdiction. Mediation is also the consent of the parties is also very important in that. But it is an adversarial in that, and it is not an adversarial. Once it is non-adversarial, you can't put a clause like an arbitration clause in an agreement that you are compelled to go for a mediation. Absolutely, it's a volunteer, it's not a non-volunteer. So that is why till this time There is no law on this subject that you'll have to go. You can definitely incorporate that the parties may explore the possibility of the resolution through a mediation process and then can go for a litigation. This is what I do not find any fetter in this regard that the party. But how far it will be enforceable and how far the parties have to go for that, that is still a very gray area one has to understand after the law that comes. The second part, I think you were thinking of you were talking about that e-commerce business.
Sir.
So the e-commerce, as you know, you are selling everything on the portal. So I think there is a disclaimer, there is a general terms and conditions which are incorporated, I think, in every dedicated software of the e-commerce. Whoever is participating has to first go and agree to the terms, and it is a very common experience. Nobody looks at that particular term. It simply says that there is a block unless you put a button or click or tick it, it will not take you further to this. Nobody bothers to read it. And there are certain clauses which are really, I would say, is very damaging for all. Nobody bothers. One has to understand this reality as well. And something cannot be compelled upon a party when he does not know that what it is. So I think that's a very introspection is required in this regard from an e-commerce. I think the companies who are really doing those and take care of this, because there are several laws which apply. I think the Competition Act, there are many laws which applies to you. So I think you have to be very careful in this regard. Mediation is a very effective tool, I must say, in case you can explore the possibility, provided both of them that come.
In fact, sir, recently we had settled not through a formal mediation, but we settled it in the Bidhannagar court. Out of the court, we went and settled it. Mrs. Soma Mondol played a very active role. She was our counsel also. But when we went for a settlement and discussion with the other company, so Mrs. Mondol changed her chair and discussed and settled it, and we wrapped up the litigation.
I think in European countries also, there is a very well-known mediation that goes between the two companies, Jews and Eris, on a sale of that particular gas pipelines or gas or something. And I think the Martha or something was acting as a mediator, and she played a wonderful role in bringing both the parties to a common platform, and the solution was there. So the European Union, they are coming with an open mind. They know the concept of mediation. That is what we want to spread the awareness, for which all these programs are organized. For you people at least, who are the first responder to a mediation, because the lawyers comes later or the referral judge comes the third, you are the first responder to a mediation. That is what we wanted to spread awareness in this. Thank you, sir. Thank you.
Lordships, I'm Shobhik Mitra from City Civil Court at Calcutta. Lordships, there is a specific provision in CPC, that is Order 10, that before framing of issues, this is a mandatory provision for sending the matter in mediation, which is not very practiced in regular manner. So can't we use or execute that proceeding provision in regular manner in civil suits, so that before going through the hearing stage, the matter can be resolved by way of mediation or conciliation? Thank you, Lordship.
Have you read the Code of Civil Procedure? There are many provisions which are never activated nor applied. That's the irony. One must have to introspect and accept. Order 10 is one of that. Normally it is never applied. Even at the time of the settlement of issues, we know theoretically that's the first date of hearing. Is it really a hearing? You have an experience in the civil court. What is done? Both the parties are directed to file suggested issues. And then within the very congenial and comfortable atmosphere, the learned judge just find out what are the common issues, find it, issues are framed. Is it really a first hearing? Was there any hearing done? Never done. That is never the object of the provisions being in place. It is the foremost duty of the judge that on the date they will invite both the counsels will briefly state the facts, and then after hearing, then the suggestions will be given that these are the issues. Both the counsels would say that these are the issues, and then the court will decide and then frame the issues. But it is not done. It is done in a very weird manner. I do not know from where they got this particular idea of inviting the suggested issues from both the parties and then framing an issue. I do not know. It does not have. Neither in the Code of Civil Procedure nor in the CRO, I do not find. Please pardon my ignorance on this, because I do not know there is any provision, but it is not done. So Order 10 is a very important, in a very recent judgment of the Supreme Court has highlighted that you should take recourse to Order 10 first before you embark a journey on a further course of action. It is the judicial officers who have to take call, and they should take call on that. You are correct. That has to be done.
Grateful, Your Lordship.
Regards to the present judges and all my fellow lawyers who are present over here. Sir, I have a very silly question maybe.
Ma'am, sorry ma'am, please introduce yourself.
Oh, myself Shoma Juarda Das from Barasat Court. A very small and a silly question. That sir, in case of mediation, what happens when a case is there, in a litigated cases mainly, and if it is referred to mediation, and then if it is settled over there, then the agreement, whatever it is done as per the law, that may be executed in the court. As per the court is there, when the court proceeding is going on, they just give the stamp that this is the legality to that very agreement. Other thing is that just now my lordship has told that pre-litigation cases may also be taken to the mediation. That in that case, if any agreement is done over there, then how come that the legality of that agreement is, what is that? That is the question.
Why? That's why it is, first thing is, don't term as a silly question. Then you must expect a silly answer to that also.
No, sir. Okay, sir.
So, agreement, once it is executed by two persons capable of entering into an agreement, it is an agreement under the Contract Act. And if it is an agreement under the Contract Act, it is an agreement which is enforceable under the Contract Act as well, or through a courts of law, or through a particular mechanism. There are various sections where how the agreement can be turned to be bad, void, voidable. All these things are there. You peoples are more trained in this regard when the client comes, that what law should apply. But it is definitely, even a pre-litigation, it is an agreement, as an agreement conceived of without taking shelter to a mediation, and it is binding between the parties. And how to enforce the agreement, you know, I should not advise that what
yes,
is
sir.
the...
But sir, my question is still different, a small difference, that is as per 25 of Mediation Act.
No, you are, then sorry, that is one thing. You are talking about court annexed mediation.
Yes, sir.
The moment it comes a court annexed mediation, because the parties have already approached the court, and the court now referred this particular matter to or dispute to a mediation, the moment it culminated into an agreement. Now there are two things which come. Even under Order 23, if the parties have compromised, the compromise petitions or the agreements are filed before the court after looking into this and found that the agreement is lawful. Can you visualize? The word which is used under Order 23 is whether the agreement is lawful. Then the court will give its sanction, and then it will partake a character of an agreement or a decree. Again, it's a grey area, judicial grey area. I am not going to say anything about it. But if you look at this rule, it talks about not only the lawful, but also the public policy, or against any other law. What the word is polluted. 3 words. So the court, once it applies its mind, it will pass a decree on the basis of that agreement. There is no difficulty.
Sorry for disturbing you. I'm saying a thing a little different. That is pre-litigation cases that has not came to the court. One is if 2 parties come to us or one of the parties came to us and he said that there will be an agreement, then we just go and make an agreement as per law, as per on the stamp duty, paying the stamp duty with the witnesses and everything. That is legal. We know we can go to the court of the law. But the thing is that if as per my lordship has just now answered a question to one of my learned friends, that pre-litigations can also be transferred to the mediation.
Madam, I think there is a dark cloud in your mind about the concept of mediation.
So maybe
what it happens, I tell you why it is required. When there are 2 disputing parties, everybody thinks that I am correct. I think nobody would say I am wrong and then go for a litigation. If he knows that he is wrong, he will never go for a litigation. So they both think that I am right. Now what happens? They are at the loggerheads. They wanted to fight. Now what is the role of the mediator? He really acts as a facilitator. He is a neutral man. He acts as a catalyst. He has a technique and a tool where he can break the iceberg if it comes before it, and then suggest the parties how can they resolve the disputes in the best possible manner to the best possible interest which they can have. This is where the mediator role comes. He is definitely not a part of the agreement, is there. Neither is a part of the dispute. He really acts as a facilitator. So if he is approached, then at least because of his expertise, because of his knowledge, because of his perseverance, because of his experience which he gained while dealing with lot of matters in the mediation, she or he can be a very good help to both of them so that they can resolve the dispute. That is what it counts. Ultimately, it will fructify or culminate into an agreement itself. It is the freedom of the parties to enter into an agreement. It will be regarded as an agreement which the parties have arrived after this dispute. Nothing more than that. That's the beauty of the mediation.
Okay, so one more question, sir. Sir, can any pre-litigated cases be referred to the mediator through DLSN?
No, the parties can approach the forum. There is no difficulty. They can approach. They are the legal aid providing authorities. I believe so. There cannot be any problem in this regard.
Sir, in that case, if they come to any decision, then what about that?
What about that? The agreement, ultimately mediation ends with what? Agreement between the parties?
Yes.
If they come out with the agreement, where is the difficulty?
So that will be as per normal agreements that we used to do.
That is the mindset, madam. When I say the example of a tree, I say that the root is the mindset. There you have to. That's your mindset.
Okay, sir. Thank you, sir.
I was a lawyer for 19 years. I believe you have not yet, I think, crossed 19 years in the profession.
Yes, sir.
No. So I know when a client comes, how to advise and how the litigation is to be ensured. We know that. And Ms. Sanyal will be the best person to answer that.
Much obliged, sir.
My lord, one minute.
My lord, part of the question
1 minute.
she is asking for the implementation
One
of the
minute.
agreement.
1 minute. Madam, you wanted what is going to happen if there is a pre-litigation mediation. Number 1. Number 2, you wanted to know that if you are in a pre-litigation mediation, you settle the dispute, how far is it enforceable? Number 3, how do you go for a pre-litigation mediation? What is the mechanism you follow? Right? We are subject to Justice Tandon. Shubhashish, please take the question and answer that. A pre-litigation mediation. Just the rule.
Actually, madam, for pre-litigation cases in commercial disputes, Section 12A is exhaustive.
No, what she was asking was not in relation to a commercial dispute. It's a non-commercial dispute also. That is what non-commercial dispute also, not a commercial dispute. We have an SOP, a standard operating procedure for these cases. So I think I do not find any hurdle in this regard that you can't approach. You can approach. I think a copy of the SOP is here or not. I think that should be circulated to her. She is not aware of that SOP where we framed this standard operating procedure in these type of cases, that how a litigant can approach or may take advantage of the mediation, where we have said that it has to be approached to DLSA and all everything. These are all there. I think has it been published? Has it been uploaded on the website? It is uploaded on the website of the mediation, I believe. Yes, it is uploaded. You can go through it. I think the answer lies there. There is no difficulty.
But I think where she is coming from is that she is trying to tell whether in the contract with the party, whether the provision of mediation can be captured there like the arbitration clause. I think she is coming from there.
No, she does not want. She was thinking both court annexed and not court annexed.
Any more questions, please, from the learned referral judges of the District of North 24 Parganas?
Can I perceive that the mind is as pure as the Gangotri water? They do not have any pollution in their mind about the concept of mediation.
Myself, Niyaz Alam, Commercial Rajarhat. There is a provision for section 12A. Normally, all litigation has to be preceded by mediation, but in urgent cases,
yes, they can approach directly to the court. No problem.
So far, I have sent all the deferred matters. 99% of them ended in failure. 99% of the mediation ended in failure.
Yes. No, that is true. That's the data. That is the hard reality. That's why I say we have to sensitize ourselves. We have to change our mindset. Unless we change the mindset, sensitize ourselves, we will not achieve the desired data. Don't go by a data. Sometimes the data may be an indicative factor, but we have to consider what are the other factors which really played a very important or a role in such manner. We have to think of that, and that is the introspection one has to do. There are multiple factors which really worked out. First thing is parties are not agreeable. Second is they have been advised to go for a litigation, and there is a complete resilience in their regard. There is nothing of that kind. And the third, maybe that the mediator is not that efficient enough that can bring it. It all depends. There are multiple factors which play. But I have seen, at least if there is a 2%, I would say is the beam of light which has been given, and I think it will spread. Today we have to. The Commercial Court Act is a very recent act. Now 12A has been introduced very recently. The parties have not really shaped their mind into this. But I believe that a lot of things are coming up, and the parties are voluntarily showing their intention to go for a mediation. I think Mr. Anirban Das was there. Many of them has agreed, and they have deposited the requisite the fees for that. They have. So I think don't go by the data that.
Moreover, it is at formative stage.
No, true. It is still at the formative stage. We can understand, but don't get swayed by the data. Don't get perturbed by the data. I think it is changing, and you will find just a reverse situation one day.
Thank you.
That may happen.
Namaskar, my lord. Myself, Sandeep Kumar Kundu, Chief Judicial Magistrate, North 24 Parganas. My question is, my lord, whether in a mediation agreement, parties can bring matter extraneous to the subject matter of the case or suit? how the concerned court will deal with that matter.
That is the beauty of the mediation. If you have not seen the code of success procedure also, if you look at order 23, there is a specific provision not only in relation to a subject dispute, even outside the subject dispute the parties can. There is no difficulty. That is what is the concept of mediation. All other related, connected, incidental, accidental litigations or offsprings from the main, if they want to bring it to an end, they can definitely. Where is the difficulty?
So parties can bring any sort of dispute between
Absolutely. Any sort of dispute is a vague term.
That should
I say offspring, connected, accidental, incidental. If it is a I may say it's a 302, it's a 323 cases where you can't. The court has said that in a criminal such type of cases, though 498 has been imbibed within this one, the mediation. That's the another. But other offences which are against, they can't.
Okay. Thank you.
That's why it says it must be lawful, public policy and collusive. 3 words are used in Rule 25 of the mediation rule.
Actually, we are just running behind our schedule. So, if their lordships permit, may we close the interactive session now, and may I most humbly request His Lordship, Honorable Justice Harish Tandon, Lordship to sum up the interactive session with the issues or questions that have cropped up, that has come up in this interactive session, Lordship.
Yes. Once again you have to bear me and tolerate me. It was a nice interactive session. Many pertinent questions, what we anticipated and what we did not anticipate, that has been given. We have taken all those questions to be very important. As my brother Judge Justice Talukdar was just saying, that we must take note of all these questions, and we will formulate frequent asked questions. That is a fact. As we get it everywhere in internet, I think the developers, these are softwares where the companies or dedicated softwares of the different companies, you will find a fact is there. So we will definitely include those questions and the answers, the probable answers to it. 2 things which really I would say is a challenging job to all of us, the questions which was there. As the judicial officer was just asked that particular questions, that whether it can expand its horizon to other class of the litigation in the guise of a mediation. I understand that he wanted that he has a magisterial powers, and there are many things which are not triable by a magistrate. Whether those have been brought within the mediation, how can he can do it? I think that is where the mediation lies. There cannot be any problem on that. You are simply ratifying and accepting the agreement. You are not saying that whether you have a jurisdiction or not. You assume jurisdiction on a mediation, and if the mediation can be done beyond the circumference or a peripheral of the subject dispute which is there before you, I don't think so there can be any kind of problem that one should have. It is really a recognition of an agreement. It is really giving a weighting to an agreement. Nothing of that kind. You are not adjudicating anything. And the adjudication lies with the respective forums. You are simply honoring the agreement which is there. You can't term it as an unlawful. It's a question of forum. I think that it should not stand in the way of doing it. Second is what I find is some confusion is there in the minds about the mediation, and more particularly the pre-litigation mediation. Pre-litigation mediation definitely is a new concept
this has now been given by an amendment having brought into it. We have to really work hard on the pre-litigation mediation. It should not be restricted to a commercial disputes only, what I believe is because of Section 12A. It must see more light into it and must be accessible to any kind of a dispute which may not be a commercial dispute and the resolution through a process of mediation. We were working on it tirelessly since past many months, and we have formulated an SOP in this regard so that the society could be benefited by this mediation process. And we wholeheartedly invite all the peoples of the society, the other stakeholders like the members of the bar, the companies who are there having a dispute, the various organizations, the government organizations, they should wholeheartedly come and take the benefits of such mediation. The institutionalization of the mediation is also one of the factors which are really playing so far as the lawmakers, in the mind of the lawmakers are concerned. And in the bill also, I find there is some kind of a reflection therein that the mediation is to be institutionalized. We have to, if it is passed by the parliament, we have to accept it. And the institutionalization will give a very wide spectrum about the mediations as well. Because all the members of the bar who are a bit skeptical about their livelihood, their loss of, the earnings, loss of brief, I think one must understand that not a loss or a gain. It is also that how much services you could render to the society. After all, we cannot divorce ourselves from the society, and our first responsibility is to a society. So I think we should see to it because it's less cost effective. It's it's not a time consuming prospect, is a concept. So one has to understand in this regard that they should encourage the mediation. The other question is more a grievance than really a suggestion, but definitely it's an eye-opener for us because as a member of the committee, as a president of the mediation board, my other two members are here. We have taken a particular one decision that the payment of the mediator, payment to the mediators, that particular fees, that must be done immediately. There should not be any pending. We have not been given this particular thing to us. We will definitely take care of that. And if there is any delay, I as a president of the mediation committee, and I take this opportunity that it is the same view of my members as well, that we'll go and see, and if there is a legitimate due, definitely that due will be paid in a short while. I thank you for the administration, the DM Sahib and the SDO Sahib and the SP and all the participants that you have come, spend some time on the holiday, that is a Sunday, which is expected to be the day for the family. Treat it as a family, so you are a part of the family of the mediation, and see that the mediation goes ahead. Thank you all. Jai Hind.
Thank you, Lordship. This is the end of the interactive session, and thank you, Dr. Subhashish Mori, for conducting the interactive session as a moderator. Now, I would request Honorable Justice Shubhra Ghosh to give vote of thanks. Lordship, come to the.
The Honorable Justice Tandon, Honorable Justice Talukdar,
the dignitaries sitting here before me, the district administration, police administration, our judicial officers, advocates and other dignitaries, ladies and gentlemen. As Mahatma Gandhi had said, an eye for an eye only ends up making the whole world blind. Rightly said so. In the words of Abraham Lincoln, discourage litigation, persuade your neighbors to compromise whenever you can, point out to them how the nominal winner is often a real loser in fees, expenses and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough. We have actually discussed on this issue the whole day through. I know all of you are hungry. It's the end of your patience, so I will not waste much of your time. By now, I think we have fairly understood the main benefits of mediation, which can be summarized like as follows. Mediation is firstly affordable, it is fair and impartial, it saves time and money, it is confidential, it avoids litigation, it fosters cooperation, improves communication, identifies the underlying issues so that other connected and incidental matters can also be dealt with at one go. Mediation allows personalized solutions, and believe me, mediation really works. The Honorable Supreme Court has shown serious concern to the huge pendency of cases before the High Court as well as the District Court. It has been repeatedly, time and again said by the Honorable Court that an active effort must be taken by the court to make negotiation and mediation mandatory as a part of case management. Imbibing effective ADR mechanisms into the judicial process can reduce pendency, save judicial resources and time, and allow litigants a degree of control over the dispute resolution process and its outcome. It is more important that the individuals are taken into the process and made to feel as insiders in the process and not outsiders to the process. That will definitely help. Today I have been honored with this opportunity of proposing the vote of thanks. It is a matter of great pleasure for me to propose this vote of thanks on behalf of the Mediation and Conciliation Committee, High Court, Calcutta. First of all, I would like to thank Honorable Justice Tandon for delivering his erudite speech on mediation and guiding all of us in organizing such regional conferences to spread the message of mediation to all the stakeholders. Without him, the whole program would not have been possible. He is the man behind it. He is the person who gives all the inspiration, organizes it, whether it's a holiday or a working day. Despite his very busy schedule in the court as a very senior judge of the court, he devotes all his time, so much of his time to this issue. We are really grateful to him. He has, in fact, spoken very eloquently, as he always does, this morning. He has beseeched the learned counsels to change their mindset. In fact, he has been candid enough to share with us that he, as a learned advocate, had a different mindset altogether and was really against the concept. Once he has got into the concept, he has come to know about it, he is aware of it, he has really changed his mindset. That he has beseeched all the learned counsels and other stakeholders to do. He has taken us to the earliest civilization of the Mesopotamians and the Sumerians. He has very eloquently stated that even at that time, disputes raised were taken to a person called the Maskin, if I have correctly heard him, the Maskin, who used to go to different villages, interact with people, understand their problems, the dispute, and then advise solutions. So mediation is not a very new concept. It has been through ages, right from the beginning of the civilization. Justice Tandon has elaborated on the fact that if dialogue can be opened, disputes can be settled and parties can be set at ease without going into all the difficulties, all the problems of litigation. He has very nicely distinguished between the concepts of mediation and litigation. According to Justice Tandon, the beauty of mediation is that it is voluntary, consensual and non-adversarial. He has also referred to the Mahabharata, where the interaction of the Pandavas with Lord Krishna has been stated by him. He also stated that the Pandavas did not want to engage in war and Lord Krishna acted as a mediator therein. It was only due to the failed mediation that the entire war of Mahabharata took place. Several legislatures have been referred to by Justice Tandon, the Commercial Courts Act, the Consumer Protection Act and the like. He has requested the judicial officers as well as the mediators, learned counsels and the other stakeholders to promote mediation as far as practicable in order to reduce the burden of litigation upon the court and to bring about a win-win situation where both the parties go home feeling happy. None of them lose in the mediation, once it is successful of course. We were gifted with the little sapling which wonderfully Justice Tandon has interpreted that the mediation is also at the sapling stage now, which will grow into a huge tree with very strong roots, which is the mindset. We are thankful to Honorable Justice Tandon for his very thought-provoking and eloquent speech. Thank you so much, Justice Tandon. Next, I would like to thank Honorable Justice Talukdar for his speech of immense academic and practical importance in the field of alternative dispute resolution in this part of the world. In his very crisp and eloquent speech, he has referred to common sense application of law, which is the mediation. Honorable Justice has emphasized on training required in every institution, including the banking institutions and other institutions besides the court, so that the most of the disputes could be solved by way of pre-litigation instead of pulling them to the court. Addressing the learned counsel, he has stated that there may be separate chambers for holding mediations to make up the turnover besides regular litigations being dealt with. He has emphasized that laws are changing and mediation is no longer an academic exercise as of now. And there really will be no harm if the disputes are settled by way of mediation, because that will solve a lot of problems, save a lot of time and, as I said, bring about a win-win situation among the clients. May I also have the opportunity to thank the Mediation and Conciliation Committee and its members for working tirelessly to make this program a success and for spreading and sustaining the process of mediation throughout the state of West Bengal and the Andamans. The State Legal Services Authority and the District Legal Services Authority, who have immensely supported this cause, are also deserve a heart-warming thanks. The District Judge, 24 Parganas and all other judicial officers of the district, I really thank you from the core of my heart for the commendable effort you have made to make this meeting a success. The district administration, the police administration, you deserve a very warm and heartfelt thank you from our side, because without you, without your cooperation, this would not have been possible. The district public prosecutor, members of the bars of Barasat, Boshirhat, Civil Court Bar Association, Barakpur Bar Association, Criminal Court Bar Association, the Bidhannagar Bar Association, Bonga Bar Association. A big thank you to all of you for your cooperation. the staff members of the District Legal Services Authority and the Subdivisional Legal Services Authorities also deserve a big thank you, a big word of gratitude from the committee. The learned advocate mediators, the staff members of the court, the paralegal volunteers, thank you so much for your participation, your cooperation, and spending so much of your valued time for this meet. A special thanks to Ms. Sanyal, who has shared her experiences with us and has spoken a lot for taking forward the mediation and conciliation concept over the state. Very interestingly, she has pointed out that we have been through this process, this concept, right from our childhood, even without realizing it. When we were very young, the quarrels between siblings, fights between siblings have always been settled by some elder of the family, the parents or some other elder. This is of course a kind of mediation, the concept having been there right from our childhood. We have only come to realize it as a structured process now. The Member Secretary, Mediation and Conciliation Committee and his team of officers and staff also deserve a big thank you for their constant and sincere effort to materialize the desire of the committee. Without your help and cooperation, this could not have happened. All the other invitees, the bank, the representatives from the bank and other financial organizations, the media, the press and electronic media who may have been present here, I thank all of you for your cooperation, your participation to this meet. Last but not the least, I heartily thank the Tourism Department, Government of West Bengal for facilitating their services and infrastructure for this program. It's a beautiful venue and it could not have been possible without their help and assistance. Every single member who have been working behind the stage, the lightman, the technicians, I thank each one of them for their cooperation, for their participation. Without all of you, without each one of you, this would not have been possible. I think I shall not waste more of your time in this. Before parting, let us all pledge to carry forward all that we have gathered today, we have collected today in our own respective ways, so that we can all contribute in our little way to the enormous task that has been taken up right from the end of the Honorable Supreme Court till the lowest rung of the judiciary and other stakeholders. Thank you. Have a nice day. Thank you so much.
Now, with the permission of their Lordship, the program is concluded with the national anthem. Please stand up for the national anthem.
Janagana mana adhinayak jaya he Bharat bhagya vidhata Punjab Sindh Gujarat Maratha Dravida Utkala Vanga Vindhya Himachal Yamuna Ganga Uchala Jaladhi Taranga Tava Shubha Name Jage Tava Shubha Ashish Mange Gahe Tava Jaya Gatha Janagana Mangala Dayak Jaya He Bharat Bhagya Vidhata Jaya He Jaya He Jaya He Jaya 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 He.
Thank you all.